We've heard repeatedly throughout the past week and a half or so that the president is not above the law. And I'd like to focus in my last remarks here on an equally important principle, which is that the House of Representatives also is not above the law in the way they conduct the impeachment proceedings and bring a matter here before the Senate. Because in very significant and important respects, they didn't follow them. From the outset, they began an impeachment inquiry here without a vote from the House, and therefore without lawful authority delegated to any committees to begin an impeachment inquiry against the President of the United States. That was unprecedented in our history. The Speaker of the House does not have authority by holding a press conference to delegate the sole power of impeachment from the House to a committee. And the result was 23 totally unauthorized and invalid subpoenas were issued as a beginning of this impeachment inquiry. After that, the House violated every principle of due process and fundamental fairness in the way the hearings were conducted. And we've been through that. I'm not going to go through the details again. But it's significant because denying the president the ability to be present through counsel, to cross-examine witnesses, and to present evidence fundamentally skewed the proceedings in the House of Representatives. It left the president without the ability to have a fair proceeding, and it reflected the fact that those proceedings were not truly designed as a search for truth. We have procedural protections. We have the right of cross-examination as a mechanism for getting to the fact, and that was not present in the House of Representatives. And lastly, Manager Schiff, as an interested witness who had been involved in, or at least his staff, in discussions with the whistleblower, then guided the factual inquiry in the House. So why does all of this matter? It matters because the lack of the vote meant that there was no democratic accountability and no lawful authorization for the beginning of the process. It meant that there were procedural defects that produced a record that this chamber can't rely on for any conclusion other than to reject the articles of impeachment and to acquit the president. And it mattered because the president, in response to these violations of the president's rights and to the failure to follow proper procedure, failure to follow the law, has rights of his own, rights of the executive branch to be asserted. And that's the president's response to the invalid subpoenas was that they're invalid and we're not going to comply with them. And the president asserted other rights of the executive branch. When there were subpoenas for his senior advisors to come and testify, along with virtually every president since Nixon, he asserted the principle of immunity of his senior advisors, that they could not be called to testify. And the president asserted the defects in subpoenas that called for executive branch officials to testify without the presence of agency counsel. All established principles that have been asserted before. Now, what do the House managers say in response? They accuse the president in their second article of impeachment, trying to assert obstruction, that this was unprecedented response, an unprecedented refusal to cooperate. It was unprecedented that 23 subpoenas were issued in a presidential impeachment inquiry without valid authorization from the House. The president's response was to a totally unprecedented attempt by the House to do that which it had no authority to do. They've asserted today, and on other occasions, that the president's legal arguments in response to the subpoena, they've said that it's indiscriminate. There was just a blanket defiance. I think I've shown that that wasn't true. There were 3 very specific legal rationales provided by the executive branch as to different defects in different subpoenas, and there were letters explaining those defects. But there was no attempt by the House to attempt an accommodations process, even though the White House offered to engage in an accommodations process. There was no attempt by the House to use other mechanisms to resolve the differences with the executive branch. It was just straight to impeachment. Now, they've asserted today and on other occasions that the president's counsel, that I and my colleagues have made bad faith legal arguments that are just window dressing. Now, in an ordinary court of law, one doesn't accuse opposing counsel of making bad faith arguments lightly. And if you make that accusation, it has to be backed up with analysis. But there hasn't been analysis here. There's just been accusation. When the president asserts the immunity of his senior advisors, that's a principle that's been asserted by virtually every president since Nixon. And let me read you what Attorney General Janet Reno during the Clinton administration said about this exact immunity. She said that immediate advisors to the president are immune from being compelled to testify before Congress, and that, quote, the immunity such advisors enjoy from testimonial compulsion by a congressional committee is absolute and may not be overborne by competing congressional interests, end quote. And she went on to say, quote, compelling one of the president's immediate advisors to testify on a matter of executive decision-making would raise serious constitutional problems no matter what the assertion of congressional need, end quote. Was that bad faith? Was Attorney General Reno asserting that principle in bad faith? And President Clinton? President Obama asserted the same principle for his senior political advisor. Was that bad faith? Of course not. These are principles defending the separation of powers that presidents have asserted for decades. President Trump was defending the institutional interests of the office of the presidency and asserting the same principles here. That is vital for the continued operation of the separation of powers. Now, House managers have also said that once the president asserted these defects in their subpoenas and resisted them, they had no time to do anything else. They had to just go straight to impeachment. They couldn't accommodate, they couldn't go through a contempt process, they couldn't litigate. But the idea that there is no time for dealing with that friction with the executive branch is really antithetical to the proper functioning of the separation of powers. It goes against part of the way the separation of powers is supposed to work. That interbranch friction is meant to take time to resolve. It's meant to slow things down and to be somewhat difficult to work through and to force the branches to work together to accommodate the interests of each branch, not just to jump to the conclusion that, well, we have no time for that. We have to assert absolute authority on one side of the equation. And this is something that Justice Brandeis pointed out in a famous dissent in Myers versus the United States, but has since been cited many times by the court majority. He said, quote, the doctrine of the separation of powers was adopted by the Convention of 1787 not to promote efficiency. So he's saying not to make government move quickly, but to preclude the exercise of arbitrary power. The purpose was not to avoid friction, but by means of the inevitable friction incident to the distribution of the governmental powers among the department to save the people from autocracy. That is a vitally important principle, that the friction between the branches, even if it means taking longer, even if it means not jumping straight to impeachment, is part of the constitutional design. And it's required to force the branches to determine incrementally where their interests lie, to resolve disputes incrementally, and not to jump straight to the ultimate nuclear weapon of the Constitution. We've also heard from the House managers that everything the president did here, asserting prerogatives of his office, asserting principles of immunity, must be wrong, must be rejected because only the guilty will assert a privilege. Only the guilty won't allow evidence. That is definitely not a principle of American jurisprudence. It's antithetical to fundamental principles of our system of laws. As we pointed out in our trial memorandum in Border-Kircher versus Hayes and in other decisions, the Supreme Court has made clear that the very idea of punishing someone for asserting rights or privileges, or suggesting that asserting the right or privilege is evidence of guilt, is contrary to basic principles of due process. And it takes on an even more malignant tenor to it when that principle is asserted in the context of a dispute between the branches relating to the boundaries of their relative powers. Because what the House is essentially asserting in this case is that any assertion of the prerogatives of the office of the president, any attempt to maintain the principles of separation of powers of executive confidentiality that have been asserted by past presidents can be treated by the House as evidence of guilt. And here their entire second article of impeachment is structured on the assumption that the House can treat the assertion of principles grounded in the separation of powers as an impeachable offense. I mean, boiled down to its essence, it is an assertion that defending the separation of powers, if the president does it in a way that they don't like, in a time that they don't like, can be treated as an impeachable offense. And that's an incredibly dangerous assertion, because if it were accepted, it would fundamentally alter the balance between the different branches of our government. It would suggest, and Professor Turley explained this, Professor Dershowitz explained it here, that if Congress makes a demand on the executive and the executive resists, based on separation of powers principles that past presidents have asserted, Congress can nonetheless say, we've decided to proceed by impeachment. We have the sole power, and this is the principle they assert in the House Judiciary Committee report. We have the sole power of impeachment. That means we are the sole judge of our own actions. There's no need for accommodation. There's no need for the courts. We will determine that any resistance you provide is itself impeachable. That would fundamentally transform our government by essentially giving the House the same sort of power as a parliamentary system to use impeachment as, in effect, a vote of no confidence against a prime minister, not the way the framers set up our three-branch system of government with a powerful executive who would be independent from the legislature. That's why Professor Turley explained that the second article of impeachment here would be an abuse of power by Congress. It would make the executive dependent on Congress in a manner antithetical to the system that the framers envisioned. So why is it that there are all of these defects in the House manager's case for impeachment? Why are they asserting principles like only the guilty would assert privileges? That's not part of our system of law. Why are they asserting that if the executive resists, the House has the sole power to determine the boundaries of its own power in relation to the executive? Also not something that is in our system of jurisprudence. I think it's because, and why the lack of due process in the proceedings below? I think, as we've explained, it's because this was a purely partisan impeachment from the start. It was purely partisan and purely political. And that's something that the framers foresaw. And I'll point to one passage from Federalist number 65. A number of different passages from that have been cited over the course of the past week. But I don't think this one has. It's just after Hamilton points out, he warns that an impeachment in the House could be the result of persecution of an intemperate or designing majority in the House of Representatives. And then he goes on. Though this latter supposition may seem harsh and might not likely often to be verified, yet it ought not to be forgotten that the demon of faction will, at certain seasons, extend his scepter over all numerous bodies of men. Now that's very 18th century language. We don't talk about demons extending their scepter over men, but it's prescient nonetheless. We might not be comfortable with the terms, but it's accurate for what can happen. And that is what's happened in this impeachment. This was a purely partisan political process. It was opposed bipartisanly in the House. It was done by a process that was not designed to persuade anyone or to get to the truth or to provide process and abide by past precedent. It was done to get it finished by Christmas on a political timetable. And it's not something that this chamber should condone. That in itself provides a sufficient and substantial reason for rejecting the articles of impeachment.